Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. We are glad to have you with us even in these difficult times. We're happy to hear argument in our first case, number 186201. You may proceed.
Thank you. May it please the court. My name is Yotam Barkheim. I'm appearing on behalf of defendant appellant Akim Al-Muwakil. I've reserved 5 minutes of my time for rebuttal. Mr. Al-Muwakil was sentenced to 280 months for being a felon in possession of a firearm. Because he received a sentence enhancement under the Armed Career Criminal Act, the ACCA, he was sentenced to more than 13 years more than he would have been otherwise. What this appeal boils down to is whether one of 3 convictions on which the government seeks to rely qualifies as a violent felony under the ACCA: attempted rape, burglary, and use or display of a firearm. As I'll explain, none of these 3 convictions qualifies as a violent felony under the ACCA. Mr. Al-Muwakil must be resentenced without the ACCA enhancement. First, as to the attempted rape conviction, the Virginia rape statute is indivisible on its face under the Supreme Court's precedent in Mathis and according to Virginia law in the Davison case. Therefore, the question is whether the Virginia rape statute can be committed nonviolently. And the answer to that question is yes. The Virginia rape statute does not categorically require the use or attempted or threatened use of physical force because it can be committed where the victim is of a particular age or where the victim falls into a particular category. The second of the convictions on which the government seeks to rely is burglary. And here, again, the Virginia burglary statute is indivisible on its face under this court's precedent in Cassandé-Lewis and under Virginia law, and it is indivisible even based on specific intent. Then, again, the question is whether the Virginia burglary statute categorically involves the use or attempted or threatened use of physical force against another. And here again, the answer to that question is no, because the Virginia burglary statute can be committed with intent to commit robbery or with intent to commit rape. Robbery is not a violent felony under Winston, and rape is also not a violent felony for the reasons that I just stated. The third conviction on which the government seeks to rely is Mr. Al-Muwakil's conviction for the use or display of a firearm. And here, the government cannot rely on Mr. Al-Muwakil's firearm conviction as a predicate offense under the ACCA under this court's decision in Hodge, because the PSR failed to designate the firearm conviction as specifically an ACCA predicate offense. Because the government failed to designate the firearm conviction as sentencing, the government cannot belatedly rely on the conviction now. For the reasons that I've just stated, Mr. Al-Muwakil does not have 3 prior convictions for violent felonies under the ACCA. We therefore ask the court...
Counsel, this is Judge Motz. Can I ask you first about the last conviction? As I read your brief, what you've asked for is that we remand to the district court for further proceedings, including resentencing. And at resentencing, if the government complied with what you think they must do with respect to the third crime, there's no barrier for giving this as a sentence that they gave, that the government gave here, right?
Your Honor, that's not quite our position, because...
I don't know if it's your position. I'm more interested in what the law is, but what your position is.
Understood, Your Honor. So the court can remand the case under the mandate rule, can remand the case for a limited resentencing. And what we're asking for, what I meant to say in terms of our position, is that what we're asking for is for the court to remand specifically for a resentencing of Mr. Al-Muwakil without the ACCA enhancement. We're not asking for de novo resentencing. So we're asking specifically that he be resentenced without the enhancement, which would remove 13 years from his sentence.
Well, I understand that, but for focus on the last, we do have 2 qualifying predicates, right?
That's correct, Your Honor.
You concede that already. So what we're looking for is that third one. Now, if you would focus on your last argument, not the burglary and not the rape, but your last argument, okay, what is to prevent the government from properly raising it in a way that you say they should have this time? And your whole argument hinges on that, right?
Your Honor,
your whole argument respects with, I'm sorry, maybe I'm not saying this clearly enough. Your whole argument with respect to this third crime hinges on whether Hodge was complied with or not, right?
Your Honor, that's correct as to the last point. So our argument hinges on whether Hodge was complied with, correct.
And if on remand the government did comply with Hodge, then there would be 3 qualifying predicates, right?
Well, Your Honor, this court can remand specifically for not a de novo resentencing where the government can again designate a new felonies. The court can remand and instruct the district court simply to resentence him without the enhancements. But as to whether the government could, on a de novo resentencing, theoretically designate the predicate, I think that the government could under this court's decision in Rumley, but there are a number of reasons which are pointed out in Hodge and in Winbush as to why that is still a problem for the defendant appellant here, Mr. Al-Muwakil. And so those issues include the fact that the burden shifts. So on a resentencing, the burden falls on the government to prove each of the convictions, whereas on collateral review, the burden is on the defendant appellant here. And there are other issues as well. Yes, ma'am.
Mr. Barkai, this is Judge Keenan. With the theory and the main concern of the court in Hodge being that of giving the defendant adequate notice, what would be the reason for us to remand for a limited sentencing when the concern for notice would be accomplished whether or not the sentencing was de novo or limited?
Your Honor, if I understand the question correctly, there's no the notice is achieved by providing notice in the PSR specifically of the government's intent to designate a felony conviction as an ACCA predicate. Here, the government didn't, just like...
Right, but if the government could have... Yeah, no, what I'm saying is that we were worried in Hodge about the defendant being afforded notice, so the defendant could marshal all the evidence in his favor to show the court why that conviction should not be counted. And if we remanded for a de novo sentencing, the government would have an opportunity, wouldn't it not, to amend the pre-sentence report and proceed on the use of the firearm charge? And why wouldn't that satisfy the concern of Hodge, which is to allow the defendant this time to get all his information together?
Your Honor,
what's unfair about that?
Well, that's exactly the situation that existed in Hodge. So on a de novo resentencing, the government could designate a felony conviction that it had not designated before, but at that point, the government would bear the burden to prove that conviction. There are other countervailing factors as well, such as that the defendant has a right to counsel at sentencing, but not on collateral review. It's more efficient to resolve ACCA issues at sentencing and not years later on collateral review. There are issues involving the preservation of evidence and the accuracy of resolving ACCA issues at sentencing as opposed to years later on collateral review. So all of those are reasons why it's important for notice and fairness reasons to require the government to designate the felony convictions on sentencing in the PSR explicitly as designated felonies. So in that respect, this case is on all fours with Hodge.
Okay, counsel, I'm not sure. Maybe we can go through those reasons because we live in a real world, as we all know, not an ideal world. And we take your point. It would have been better to designate them first round, but they didn't. And now we're looking to see what needs to be done to comply with Hodge. if we should vacate this and send it back to the district court for resentencing. And I understand your reasons, but clearly the defendant would have notice now and an opportunity to prepare, as Judge Keenan said, whatever information or whatever he can say in response to that. And I'm not sure I understand what these other points are. Are you saying that what other requirements would need, or what would make resentencing on that issue problematic here? I'm just not following your argument.
Your Honor, what Hodge says is that the government, in order to provide the notice that is required and the fairness that's required under Hodge, what Hodge says is that the PSR must specifically designate convictions as ACCA predicates. And so on a de novo resentencing, the government would have to specifically designate an offense.
Okay, I get that. All right. I understand that. They would have to...
I'm sorry.
Sorry, go ahead.
And didn't we say in United States versus Rumley that the government could do that was acceptable for the government to designate new prior offenses as ACCA predicates at the de novo resentencing?
Yes, Your Honor. This court said that in Rumley. That's right.
Okay.
So, the government would have to do that. What else would have to be done to comply with Hodge and Rumley?
Your Honor, the government would need to specifically designate a conviction as an ACCA predicate, but that's not what happened here, which is why we're asking for a remand and resentencing.
This is Judge Oakey, if I could ask a question. I wanted to understand, counsel, your argument with regard to prejudice, which I can see if the government attempts to present in the Court of Appeals a conviction that was not previously designated in the trial court through the PSR, that obviously can't raise it on collateral review. But in this case, you have a fairly old conviction, assuming they used this firearm during an abduction from the 1980s. So is your argument that the intervening couple of years between the original sentencing and a de novo resentencing is the prejudice, or is it something else?
Your Honor, that is one of the forms of prejudice. That's correct. So Hodge and Bush.
All right.
Yeah.
Well, I'm not sure how many years it's been, but it's only been a couple. What's the difference between, and in this case, there would have been, 30 years passing between the conviction for using or displaying a firearm and the commission of a felony and the original sentencing in 32 or 33 here? How is that incremental couple of years prejudicial?
Your Honor, first, the sentencing happened nearly 20 years ago now, so it has been a number of years since the sentencing itself occurred, and that in and of itself is prejudicial. And then in addition, it is what Your Honor said, it's the additional passage of time between the conviction and the sentencing, but it's also the fact that, as I said earlier, and as this court said in Hodge, the burdens flip on collateral review as compared to where they were at the sentencing. There's a right to counsel at sentencing, but not on collateral review. There's also a need for a certificate of appealability on collateral review, which obviously is not there at sentencing. So there are a number of reasons why it becomes prejudicial to the defendant to have to litigate an ACCA predicate here today on collateral review as opposed to doing it on sentencing when the government bears the burden.
So this is Judge Agee again. So if the sentencing were 2 years ago and there was a gap of 2 or 3 years between sentencing and a de novo resentencing, would that change your answer?
Your Honor, I think that the concerns still exist. So the concerns exist in part because of the passage of time and the loss of evidence and the accuracy concerns, but that's certainly not the only issue that exists. And a lot of that, again, is, as I said earlier and as the court has said, a lot of that has to do with the burden borne by the government as opposed to the burden borne by the criminal defendant, and the fact that the criminal defendant, for example, has a right to counsel at sentencing, but not on collateral review. There are a lot of reasons that are all laid out by this court in Hodge and in Winbush. There are a lot of reasons why it is extremely prejudicial to a defendant to not have that notice of the ACCA predicates on which the government seeks to rely, and to have to guess at what the government seeks to rely in order to receive the ACCA enhancement.
Counsel, I'm sorry. I'll let you go to the two issues that I know you want to talk about, but I'm just really not sure why we couldn't direct the resentencing the way you wish. If there would be counsel, you certainly would have notice now. If we wished, we could even say the burden of proof would be on the government. What am I missing? Because I do feel like we're not meeting here. We don't have to agree, but at least have to understand what you're saying.
Well, Your Honor, the circumstances that you're describing are exactly the same circumstances that existed in Hodge. That's the same situation that existed in Hodge, insofar as what the court held was that the defendant lacked notice in the PSR of the felonies on which the government sought to rely, and therefore couldn't object to them. And this court remanded for resentencing of that defendant, and that's what would happen here. My client should have the opportunity on sentencing to fully litigate the ACCA enhancement, the predicate felony of use or display of a firearm, which here he was unable to do because he lacked actual notice in the PSR of the fact that the government would later seek to rely on it. And so Hodge directly controls this case, and I hear that my time has expired, but just to complete my thought there, if I may, so Hodge directly controls this case in terms of the outcome that was ordered there, and we're asking for the same outcome here. Thank you.
Counsel, why don't you take an extra 5 minutes and talk about your other two arguments, or whichever one you wish to, and we will give your opposing counsel extra time too.
Sure, Your Honor, I'd be happy to. So the moving away from the use or display of a firearm, the attempted rape conviction that Mr. Al-Muwakil has cannot be relied on by the government as an ACCA predicate offense for the reasons that are stated in our brief and also in the Davison case. The Virginia Supreme Court's recent decision clearly answers the question of whether the Virginia rape statute is divisible or indivisible. It clearly requires the court to find that the Virginia statute is indivisible, and as a result, the question then becomes whether the Virginia rape statute requires the use or attempted or threatened use of violent force. And because some of the factual means by which the Virginia rape statute can be violated include the fact that the victim is of a certain age, or the fact that the victim falls into a specific category, as a result, the Virginia rape statute does not categorically require the use or attempted or threatened use of violent force. As to the burglary, as I stated, the Virginia burglary statute is indivisible, even by specific intent. And so the question again becomes whether the Virginia burglary statute can be committed in a nonviolent manner through even in looking at the particular intent to commit a particular crime. Those are factual means, those are not elements of the offense. And here, because the Virginia burglary statute can be committed with the factual means of intent to commit rape, which we just discussed, and robbery, which under the court's decision in Winston is also nonviolent, the Virginia burglary statute does not categorically require the use or attempted or threatened use of violent force.
Okay, Mr. Barkai, this is Judge Keenan. could I back you up just a little bit on your analysis of the breaking and entering with the intent to commit murder, rape, or robbery? And my question to you is, why is that indivisible? Aren't these different elements of the crime? That is, intent to commit rape is a different element of the crime from intent to commit robbery. And that is a different element of the crime from intent to commit murder. Why aren't these three separate elements of the crime of statutory burglary under Virginia Code Section 182-90?
Your Honor, they're not different elements, because the element of Virginia statutory burglary under 18.2-90, the element as relevant here is an intent to commit a particular crime, but which crime is being committed under the statute is a factual means. And that's based on the plain language of the statute. It's also based on Virginia's model jury instructions, which state clearly that there are two elements, one of which is the breaking and entering, and one of which is the intent.
Right.
It's also...
Mr. Barkai, I don't mean to cut across you. And I think this is you've got a really good argument on that point, but what's hanging me up is what the Supreme Court has said in distinguishing means from elements. And it seems to me that we've got a serious direction from the court in Decamp looking at the issue of elements. And why don't we have distinct elements here in intent to commit murder, intent to commit rape, intent to commit robbery, irrespective of how Virginia instructs juries and irrespective of how we have ruled in robbery and rape? It just seems to me, under the whole analysis of the categorical approach and indivisible crimes versus divisible crimes, which is federal law, that you maybe have a problem with your argument because these are elements rather than means. Could you address that?
Yes, Your Honor. The first thing that I would say is the Castanet-Lewis case, which is this court's decision on the divisibility of 18.2-90, states that the statute cannot be divided into alternative elements, and we're not aware of any case of this court or another court that analyzes the burglary statute and concludes that it is divisible based on specific intent.
Okay, but Castanet-Lewis was talking about location. In other words, were you inside the house and stayed in the house, or did you turn the doorknob and go into the house? That's clearly talking about means. How did you go about accomplishing the crime, as opposed to the distinct concepts of rape, robbery, and murder? So if we don't agree with you that Castanet-Lewis analysis controls, what's your next best argument?
Your Honor, our next best argument has to do with the plain language of the statute and the model jury instructions, which under this court's and the Supreme Court's decision in Mathis, which are obviously those are federal cases about divisibility. The model jury instructions and the plain language of the statute are looked to and are consulted in determining whether the burglary statute is divisible or indivisible. So
okay, just let me follow through if I could then, and the last time I promise. In my view of the record, in trying to do, if we disagree with you as to the divisibility of 18.2-90 with regard to the intent of the defendant, are there any Shepard-approved documents in this record other than the indictment in the Virginia case?
Your Honor, I am not aware of others in the record.
Okay, thank you.
On this same point, can I ask you just one question that might be yes or no? Is it your position that when you have when you're dealing with intent, that can never be an element?
Your Honor, we would not take the position that intent can never be an element. But here, the intent to commit a particular crime is one of the two elements of this statute. So 18.
No, I understand your position. I just wondered how far this argument went.
No, we would not take the position that intent can never be an element. No, Your Honor.
Okay.
Counsel, this is Judge Agee. Let me ask you along that line. Is it your view that in giving the jury instruction on statutory burglary, if there was evidence of an intent to commit murder, an intent to commit rape, an intent to commit robbery, that the jury could be instructed as to all of those and unanimity would not be required?
Yes, Your Honor, that's our position. That's similar to what the Virginia Supreme Court and the Virginia Court of Appeals said in the Davison case, which is that in the context of the rape statute or the sexual offense statutes under Virginia law, that the jury does not need to be unanimous as to the particular factual means. So here, looking at the Virginia burglary statute, the jury does not need to be unanimous as to which of the crimes listed in the statute the defendant needed to have the intent to commit. The jury just needs to be unanimous as to the fact that the defendant needed to have the intent to commit one of them. And so
are you saying that? I'm sorry.
No, I was going to ask, do you have a Virginia case that supports that view of the jury instruction? Specific to statutory burglary.
Right. I see what Your Honor is asking. The jury instructions are discussed and interpreted in this court's decision in Cassandé-Lewis, which is not a Virginia case, but they are relied on by this court in that case.
But Mr. Barkai, Judge Keenan, again, the indictment in the state court case said breaking and entering with the intent to commit murder. So how could the jury return a verdict saying that he broke and entered with the intent to commit rape? You're saying when the indictment specifies the intent to commit murder, that the jury could come back and he could be convicted on intent to commit rape?
Your Honor, that's not quite what we're saying. So we acknowledge that that's what the indictment says, but the indictment did not need to say that under Virginia law. So if
right, but it did say that. It did say that.
But so, yes, Your Honor, but the categorical approach states that unless the statute is divisible, we're not supposed to look to those materials. So the categorical approach is about whether the statute is categorically violent or nonviolent, just based on what the statute says, as well as what Virginia law and model jury instructions and so on say. So as a result, what the indictment of Mr. Al-Muwakil said here is not relevant to the categorical approach. It's simply unless we disagree with you and find that it is divisible, then it's highly relevant, isn't it? Yes, Your Honor. I heard a ringing which indicated that my time may be expired. I'm not sure. You have other?
I think that's right. Thank you very much. Do my colleagues, Judge Keenan or Judge Agee, do either of you have further questions?
No, thank you.
No, thank you.
Thank you so much,
thank you.
Counsel.
Thank you.
Good morning, Your Honors. My line cut out for a moment. Are we all right to proceed?
Right. We're glad to have you back.
Thank you, Judge Moss. May it please the Court, because the defendant has conceded the existence of two violent felonies, the Court really need only address one in deciding, or need only find one in order to affirm. And as our briefing lays out, there's multiple paths to that affirmance, we think. Some are more procedurally complex than others. Given the Court's questioning of my friend on the other side, I thought I would start with the remedies for the use of a firearm prior conviction. I think, assuming that the Court disagrees with the government as to the existence of actual notice in the PSR, and the applicability of Hodge. I think our position is that Rumley requires a de novo resentencing in this context. I think Rumley did not just say this was permissible, but actually looked to 3661 about the limitations of information that can be introduced in sentencing and the Supreme Court's decision in Pepper, and said that essentially artificially curtailing what can be considered on a resentencing would contravene that area of the law. So in that context, even if the government were to lose all of the predicates as a matter of collateral review, the remedy here is appropriately a de novo resentencing at which, as your honors pointed out, defendant would again be entitled to counsel, where the government would bear the burden of proving the existence of the prior convictions by a preponderance of evidence, and so forth and so on. So all that to say, I think Hodge sort of ends at the collateral review stage and says the appropriate remedy is resentencing, whereas Rumley is the decision that controls what happens after the order for resentencing and what information needs to be available to the court in the subsequent resentencing.
So just so I'm clear, because this is a little bit of a complicated case, there's nothing that a defense counsel has said that he would need, or that his client is entitled to, on the resentencing for this count that the government does not agree that he is entitled to. Is that correct?
I think that, I'm not sure I understand your question, Judge Moss. I think the concerns that animate Hodge, the existence of notice, the relative burdens between the defendant and the government on collateral review, and the right to counsel, all of which would then be sort of back in their original state on a de novo resentencing. Once the government can rely on that, once we're in that phase, the government can then present its evidence of a qualifying prior conviction, and we end up again with the same sentencing range. Now,
and the burden was on, and who would the burden be on?
I believe in the same as in an ordinary sentencing, Your Honor, the government would bear the burden to prove facts that establish sentencing by preponderance.
Okay, so then that leaves
sort of back
the
to
only
square
thing.
Zero.
Right. The only thing that I can come up with in my notes, and maybe your colleague on the other side will correct me, is the prejudice problem, right? That Judge Agee discussed with your colleague?
So I think the prejudice inquiry is relevant to whether this court needs to remand for resentencing on collateral review at all. Given the age of the conviction, it actually sort of hurts the government more in the sense of if we don't have the records anymore.
If it's your burden, yeah.
Right. If it's our burden, the age of the conviction and the length of time sort of works against us because we then have to reprove it in the second resentencing. So I don't think that's a consideration for the resentencing area. We framed this argument as sort of the back end of collateral review on harmlessness, where the fact of the conviction was proved at the initial sentencing, and there's nothing in the record that indicates that it's vulnerable. And so where we're able to make an argument, and defendant has counsel in this case, and is able to argue against the existence of use of a firearm being a violent felony, we think this sort of falls into a harmlessness analysis on collateral review, even where Hodge says this was error in the first place. And Hodge didn't address harmlessness, so it's sort of a lacuna in the law about what to do when Hodge says there's been an error, but there's a harmlessness argument on the back end. So we sort of framed it as if we would be able to prove this again in resentencing and we meet the harmlessness standard in collateral review in showing that, then the court doesn't need to remand for a resentencing at all because the error didn't have a substantial and injurious effect on defendant.
But that is no longer your position given Rumley? Is that right? Because I didn't understand that as your position in front of us right now.
We would make both arguments, Your Honor, that there is an appropriate harmlessness review, and I think Rumley confirms that the error would be harmless because we would just be back here on the exact same posture. The same sentencing range would apply, the same statutory range would apply after the resentencing. So we're saying that because Rumley sort of necessarily says we are able to introduce evidence of this and we'd end up with the exact same sentencing range, there actually isn't a substantial and injurious effect on the defendant's sentence for purposes of collateral review, and no remand is necessary at all. The court might disagree with us on that, but it operates in two separate phases.
Okay.
I thought I would move to, unless the court has any more questions on sort of Hodge's remedy context, I thought I would move to what I think is probably the simplest ground for affirmance in this case, which is the burglary conviction. We obviously disagree that Cassandra-Lewis controls. That dealt with the enumerated offenses clause, and the holding of that case is that Virginia robbery is broader than generic federal burglary, and the means element distinctions discussed in Cassandra-Lewis were just locational and temporal, not the specific intent component. And I think for purposes of Virginia law, I think the cases of Taylor from the Virginia Supreme Court and then the en banc decision in Maynard from the Virginia Court of Appeals make it clear that the Commonwealth, when charging someone with a specific intent burglary, is required to charge exactly one specific intent and then prove that specific intent. In Taylor, for example, the Supreme Court said that it's not permissible, even in dealing with a statutory burglary statute that says, or a felony or has intent to commit some felony, that you can't just charge a felony. You have to name the felony and then prove that felony to the jury. And similarly in Maynard, which dealt with the generic burglary statute in Virginia, which says breaking and entering a dwelling in the nighttime to commit larceny or a felony. The Virginia Court of Appeals said you charged larceny, but you didn't prove larceny. You only proved an intent to rape. Now, an intent to rape would be another felony. So I think that cuts against defendants' argument that a jury could non-unanimously find different specific intents and it would still be a valid conviction. I think between Taylor and Maynard, Virginia burglary really has to be limited to specifically one.
So, counsel, this is Judge Agee. If I could ask you questions similar to what I asked opposing counsel, is it your view then under Virginia law that if the indictment was worded so that it was the intent to commit murder, rape, or robbery, would that be a valid indictment?
I don't think so, Your Honor. I think Taylor demonstrates the way that it would have to be indicted. In Taylor, there were 3 specific burglary counts in the indictment, one, and each charged a different specific intent. So my understanding of Virginia law, and I realize who I'm talking to in this context, but my understanding of Virginia law is that the indictments would have to charge them as separate counts because the different specific intents would be required to be proven in that context. So I don't think you could sort of disjunctively charge specific intents in a single count of the indictment.
So long as to follow what I understand your argument to be, if it, as in this case, the indictment charged, I believe, only murder, that would be decisive in the divisibility analysis, in your view, that the indictment, having been circumscribed in that way, restricts the analysis only to that one particular crime for intent?
Correct, Your Honor. That there is no way this defendant could have been convicted on any specific intent other than murder.
But
I think that's where...
Okay, but Mr. Grano, if the crime then as charged in the indictment, which it was, is burglary with the intent to commit murder, it doesn't require, the intent to commit murder doesn't require the use of force or attempted use of force, does it? In other words,
I think it does.
Well, if I break into my old boyfriend's house, okay, I have no permission to enter. I still have the key. I break in, and I want to kill him. I'm just tired of it, tired of his existence. Okay, I have a gun in my backpack. It's loaded. I break in, and then somebody catches me. I have broken and entered with the intent to commit murder, but I haven't attempted a use of force, have I? Because I haven't taken any step other than the breaking, I haven't taken any step to commit murder, have I?
Yes, Your Honor, because I think you have...
I'm sorry, because I think Virginia law, doesn't it pretty clearly break down that an attempt crime can be proved either by a statement or by conduct? And so you don't have to have conduct in particular. If I had that intent and I told Judge Motz I was going off to kill my boyfriend, and then I committed the act of breaking and entering, how would I have committed force with regard to the crime of attempted murder?
There's two points I think that I'd like to make in response. The first is that what constitutes an attempted use of force here should be defined exclusively by federal law, because we're not dealing with an actual Virginia attempt crime. So we're not doing the same kind of analysis that Dozier does, where you have to compare the elements of the state attempt crime versus the federal attempt crime. Our argument is that the co-ate crime of burglary with intent to commit murder is, for federal purposes, an attempted use of force, because breaking and entering, the acts required for burglary, are a paradigmatic black letter substantial step towards accomplishing the intent to kill, which is a specific intent to use deadly force. So that's step one. And step two is, I think the Virginia standard on Virginia law is an act that accounts as I believe, the commencement of the consummation of the crime. So to the extent there was any kind of analysis that required looking at the Virginia standard versus the federal standard, I think Virginia may even be a little bit more restrictive on what constitutes an attempt.
So you're saying the act of breaking and entering is a sufficient use of force for purposes of the ACCA?
No, Your Honor, I'm saying that it is a substantial step that qualifies in the attempted use of force analysis. So if we look at this court's decision in Pratt, which cited the model penal code for the standard for attempt, unlawful entry into a structure or a vehicle is listed as a paradigmatic substantial step towards completing a crime. And here, the other element of federal attempt is a specific intent, and here the intent is to kill, which is to use violent deadly force. So we're saying that when you pair an intent to use deadly force with an act that by definition constitutes a substantial step towards accomplishing that intent, you have committed a federally attempted use of force. I don't know if I'm explaining that correctly, but I think
I think what you're saying.
Disconnect.
I'm not.
Okay.
I understand.
I think the difference is that in most cases, we're dealing with whether or not a state attempt crime constitutes a federal attempt, meets the standard of an attempted use of force for federal purposes. And here, it's a co-ate crime that also happens to be, in our view, a federal attempt to use force. But I think that this actually is reflected in Virginia's own structuring, because an attempted murder in Virginia is actually a less serious felony than burglary with the intent to commit murder, rape, or robbery. And so, in Virginia's eyes, this is the more serious offense. And in our view, too, this is perfectly consistent with Congress's intent to punish serious acts that were designed as an attempt to use force. And so
you're saying then that there doesn't have to be any attempted use of force to show murder other than the act of burglary.
I'm saying that burglary constitutes a substantial step.
I mean, the breaking and entering. The breaking and entering is sufficient to show the attempted use of force to establish the attempt to commit murder.
Only where, as an element, the burglary statute also requires an intent to use violent deadly force. So I would not say, for example, generic burglary to commit larceny constitutes an attempted use of force. I think because we believe the Virginia statute to be divisible, where the act of breaking and entering is conjoined with a specific intent to use violent force, you have, in essence, created an attempted use of force crime. And to Judge Keenan's question about the Shepard documents in the record showing this, I would note that the defendant actually pled guilty to this offense. So on page 92 of the joint appendix, it has the defendant's guilty plea to the indictment as charged. So we know that this was, in fact, the crime that the defendant was charged with and then pled guilty to as amended. It initially had a while armed with a deadly weapon enhancement that was then struck out, I assume as a result of plea bargaining. So I think the Shepard documents as relevant here establish that this defendant could have been convicted of only burglary with the specific intent to commit murder.
Right, but you do agree there are no other Shepard documents than the indictment in the state court case. Is that correct?
Correct. The indictment and the record of the guilty plea, which I think are two separate documents in Virginia, but yeah. And the other point I wanted to make on this is my friend said that we don't look to the indictment when determining whether or not a statute is divisible, and I disagree slightly. In Mathis, Justice Kagan actually said that by looking to things like indictments, we can determine how state prosecutors charge offenses, and where you charge only one of alternative terms in a statute, that's an indication that it's charged as an element as opposed to being charged as alternative means. And I think we have that illustrated in our indictment here, which charges alternative temporal means in the daytime or in the nighttime, but includes only one specific intent as to murder. So I think that's further evidence that in Virginia, these indictments are charged separately with each specific intent forming a separate crime.
Have you found another case in which intent has been regarded as an element crime?
Well, Your Honor, I'd say in Virginia, do you mean, Your Honor?
Well, yes, but give me one anywhere.
Okay. So, well, in Ridley, in 1979, the Virginia Supreme Court said that when a specific intent is necessary with an act, it combines to form, becomes a necessary element. So, and there's a line of cases in the Virginia Supreme Court saying that the specific intent becomes an element when it's charged when a statute requires it in conjunction with a particular act. And then I would also note that this court's decision in Townsend, which was assault with a deadly weapon with the specific intent to kill, I believe from North Carolina, the court looked at specific intent to kill as an element of that offense and said, because the statute requires a specific intent to kill, it necessarily requires sort of at minimum an attempted or threatened use of force, because the person is attempting to use deadly force. And then there's some other act, in this case, assault with a deadly weapon, that counts.
Maybe you're answering this question, but I'm not sure if you are. What I'm really, it seemed to me that you were trying to line this up with the earlier case that we had, I guess, Judge Diaz or Judge King's case, that talked about the temporal elements being separate elements, and you were saying that the intent elements here were too, and I just wasn't familiar with this in any of our recent ACCA cases where we looked at different intents as elements of the crime. Are you answering that question?
I think so, Your Honor. I think in Townsend and in Burns-Johnson is the other one that I'm thinking of. The court conducted an analysis, Burns-Johnson was it was robbery with a dangerous weapon. So here's some counterexamples. So for Simmons and Mills, this court held that reckless assaults with deadly weapons, because the relevant state statutes could be committed recklessly, that wasn't sufficient to show that these were uses of force. And so I think in a similar way, we can look to the specific intent to kill, as the court did in Townsend, as an indication that the intent in the state crime matches the intent required in the federal crime, which for our purposes would be an attempted use of force requiring what we think is a specific intent to use violent force.
I think I'm asking you a somewhat different question, and that is...
Okay, I apologize.
Well, maybe I'm not clear. I'm sorry, not clear. But I thought you were saying that there were three separate crimes here because it was intent to commit three separate crimes, right? Is that true?
So I think the Virginia statute has as alternative elements three different specific intents.
So, but that would make it divisible along those lines, right?
Correct.
Because of the three, yes. And what I was asking you is, you know of another case in which courts have held that. They've had 2 or 3 or 5 or whatever different kinds of intent, and they've divided it, the statute, the divisibility analysis along those lines.
I see. No, Your Honor, I'm not aware of one off the top of my head. I would imagine, given the way some states structure their state codes, there might be sort of lesser included and greater included versions of the offense. And so the court may have done divisibility analysis dividing by specific intent based on sort of reckless assault versus intentional assault or so on. But I don't have a specific case. If Your Honor likes, I would be happy to submit a supplemental.
No, that's fine.
If I can find one, but
yeah, okay.
No, standing here, I don't have a case where the individual intents in a statute were the basis of the divisibility analysis.
Okay. Do you have anything
I would just say
further?
that not unless Your Honors wishes me to discuss the impact of Davison and the attempted rape count, I would be happy to talk about what we think separates, but I realize I may be at the end of my time. I haven't heard the bell yet. But...
Yeah, Mr. Randall, let me follow up on your point saying that the act of breaking is enough force to establish the attempted use of force. How can opening a door with a key qualify as a use of force under Johnson?
So, Your Honor, I don't think...
You still got to meet the Johnson definition. Excuse me one second. You've still got to meet the Johnson definition, don't you?
I agree for uses of force, Your Honor, but not attempted uses of force. So our position is that the separate attempted use of force in the elements clause does not require actual force to be used as long as the crime meets the definition of a federal attempt, that is the specific intent to use force and a substantial step towards accomplishing that use of force.
See, Mr. Brandon, what I'm worried about is that one of us is off base here. And my concern with your argument is that perhaps, and I've got to think this through, but perhaps you're equating burglary with the intent to commit murder into an attempted murder. And you don't have to show the attempt. You have to show the intent to commit murder. And if the defendant has the intent to commit murder and took the step of breaking into the dwelling, that you could have burglary with the intent to commit murder irrespective of any attempt to commit murder. Does that make sense?
I think I understand where we're slipping, Your Honor, but I think I just disagree. I think that in our view, it's not required that it be an attempted murder as charged in the state, for example. But let's say the charge was attempted murder, and the substantial step in the case in an attempted murder trial was the breaking and entering of a house. Under the Model Penal Code and federal law, that is a sufficient substantial step to constitute attempted murder.
Right, but we're talking about Johnson and the use of force in order to qualify for ACCA. And how does opening a door with a key qualify as the use of force under Johnson?
I don't think it qualifies as a use of force, Your Honor. I think it qualifies as an attempted use of force. And this may be the distinction that I haven't made clearly yet. So in the elements clause, a crime could be a violent felony if it involves the use of force or the attempted use of force or the threatened use of force. And we think those are all independent requirements. And so something that doesn't actually involve the use of force still must necessarily be a violent felony if it constitutes an attempted use of force. And in interpreting what the attempted use of force in 924E means, we look at federal law because attempt is a common law term. And so when Congress uses the term attempt, we assume that it's importing the common law meaning. So to be an attempted use of force, our view is that the government would have to prove that the defendant specifically intended to use violent force and took a sufficiently substantial step towards accomplishing that use of force. And that constitutes an attempted use of force. And then the interesting thing...
Go ahead.
Just the interesting thing about this case, which I think makes it more confusing than it sometimes needs to be, is that the substantial step in this case is its own completed crime, in this case, burglary. So in a case in which you had been charged with attempted murder or even federal attempted murder, and the substantial step was breaking and entering a vehicle, that would be sufficient to constitute attempted murder. So burglary with the intent to kill in Virginia is a variation or a very specific type of attempted murder almost for federal purposes.
Okay, thank you.
Judge Agee, do you have any further questions?
No, I do not.
Judge Keenan, do you?
No, thank you.
Counsel,
thank you very much.
We understand your argument. Thank you.
Your Honor, I'd like to focus on the Hodge issues, if I may, on rebuttal, that the panel was concerned with.
Mr. Barkai, this is Judge Keenan. I think you also, I would advise you to focus on Mr. Grano's argument with regard to burglary with intent to commit murder.
Yes, I'd be happy to, Judge. I'd be happy to, Judge Keenan. So to address Hodge quickly first then, either argument made by the government, either viewing this in terms of harmlessness analysis or under Rumley in terms of a de novo resentencing, either outcome would be a gutting of Hodge, which obviously controls this court. So what the court said in Hodge is that if the predicate felony, if the PSR does not designate as predicate felonies the specific convictions on which the government seeks to rely, then the defendant is not on notice of the need to challenge those convictions as predicate offenses under all of the burdens that we've been discussing that apply to that stage in the criminal proceedings. Here, moreover, Judge Dumar, who performed the sentencing, as we said, approximately 20 years ago, was operating under a mandatory guidelines regime and clearly was displeased with the sentencing range that resulted and said at sentencing that he did not like the sentence that he was, the sentence guidelines that resulted from the calculation. So it would be conjecture to say that the result would be the same, that the sentencing range would be, that the sentence would be the same, to say that the posture years later in collateral review would be the same. So for that reason, we can't say that harmlessness analysis applies here. And similarly, the fact that Rumley said that the government may later designate a conviction as a predicate offense on a de novo resentencing, that also does not mean that the court should not order a resentencing here. Either viewing this through the lens of Rumley or through the lens of harmlessness analysis, it's crucial under Hodge that the defendant receive actual notice of the government's intent to designate a violent felony in the PSR so that the defendant can challenge it. And to say that the result would be exactly the same is, I think, incorrect in light of what the judge said at sentencing and the mandatory guidelines that applied. And in any event, even if it ended up being correct, it's certainly conjecture of the type that is not well suited to affirming a sentence that is, as I said earlier, 13 years longer than it would have been otherwise. Unless the court has further questions on the Hodge issues, I can move on to the burglary issues. We obviously disagree with the government as to the divisibility of the statute. The statute is, in our view, indivisible on its face and under the Virginia model jury instructions. And although the government seeks to rely on the indictment under Mathis, in our view, there's no need to go to the indictment when the statute is clear. The panel's questions, we think, were identified correctly, that the government does not identify any case law and does not cannot point to a case in which this court or Virginia court identified a statute as being divisible based on different elements of intent. So here, while obviously we concede that the indictment happens to specify a particular intent, an intent to commit a particular crime, it was not necessary under Virginia law for the indictment to do so.
Okay, Mr. Burkett, please get to answer Mr. Grano's point. He's saying that you can show attempted use of force under Johnson by the act of turning a key in a lock if you do so with the intent to commit murder. That the attempted use of force under Johnson is satisfied by the act of breaking sufficient to qualify as the attempted use of force under the ACCA.
Yes, Your Honor, that we disagree with that position, and it's not a position that's supported by any of the case law on the ACCA, as far as we can tell, and the government didn't identify any case law just now that supports it. The intent to commit murder, although we obviously disagree that the statute is divisible into that particular crime, but even if it were, the intent to commit murder does not mean that the act of burglary involves the attempted or threatened use of force, which means the attempted or threatened use of force under Johnson means an action that is capable of inflicting violence on an individual, and simply breaking and entering into a home with intent to commit murder, even if it were a crime, does not carry with it that attempted or threatened use of force. So we certainly would disagree with the government on that score. I heard my time expire, but I'm happy to answer any additional questions on that if the panel has additional questions.
Mr. Barker, I just want to be sure that you fully responded to Judge Keenan's concern. Judge Keenan, are you satisfied with that answer? Do you want to pursue it a little more?
Well, I understand his answer. I think it's a close call, but I don't know that further questioning will help in that regard.
I mean, do you have anything more to offer to us? It was, frankly, it became closer while your colleague was arguing than it had in my mind before that. And I just want to be sure that we have your full response, Mr. Barker. But yes, that's all you have. It's all you have.
No, I appreciate that. I think that I think that the previous colloquy explored that, and we don't have anything further on that point. The only additional thing that I would say is that it's obviously it's an argument raised by the government in its brief that I don't believe relied on applicable case law, and so to the extent that it's a new argument relying on no applicable case law, we don't see a basis for making that argument.
Okay. If no one has any further questions, hearing none. Mr. Barker, were you court appointed?
I was, Your Honor.
Well, thank you very much. You've done a fine job for your client. We really appreciate your efforts. How did you happen to get on our court appointment list?
Thank you, Your Honor.
Don't you?
Yes, Your Honor. I'm located in New York. Your office accepts applications to be appointed as pro bono counsel from around the country.
Everywhere. Okay.
That's right. So I just reached out and I asked whether there were any appointments, and you had one available. So I really appreciate the opportunity. It's been a privilege to
you got a
dilly.
You. I'll say that for you. Thank you very much. We appreciate the argument of both counsel.
Thank you.
We'll take a short recess, I think.
Yes,
what we do.
I will. I will do that, and then afterwards, judges, I'll be calling you back once I have all the attorneys for the second case on the line. Okay?
Okay, great.
Thank you so much.
Thank you. The court will take a brief break before hearing the next case. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Judge Mott, you can proceed.
Thank you very much. We'd be delighted to hear argument in number 182438, Addicts Energy SA versus MBA Yasa H. Mullah. Counsel? Mr. Power?
Yes, Your Honor. Thank you. This is James Power, counsel for Yasa Mullah. As we set forth in our briefs, we believe there are 5 areas in which the district judge erred. In particular, I will go through the following. Several of the issues which, if found in favor of appellant, would moot the remaining issues. So I will focus on the ones that are 100% dispositive, would be 100% dispositive of the case. First and foremost, we believe that the district court lacked admiralty jurisdiction to issue a warrant of arrest against the vessel, as the claims brought by addicts were not maritime claims, but were merely claims arising from a breach of a settlement agreement, which does not confer maritime jurisdiction or federal subject matter jurisdiction of the court. The second issue is, we believe, that the district court erred in granting a U.S. maritime lien pursuant to the U.S. Maritime Lien Act. Thirdly, and another dispositive issue, is that addicts did not have standing to bring the claim where the very invoices in which it issued to the purchaser of the fuel stated that it assigned the rights to the receivables.
Mr. Power, this is Judge Agee. Let me stop you at the standing point. Obviously, if ADAX does not have standing, there isn't much more that we could do now. But I noticed in your briefs that between the opening and reply, you spent only 3 pages combined with regard to the standing argument, which would seem to me to be the absolute threshold for our determination of the case. Could you tell us in a little more detail exactly why ADAX does not have standing, and if they don't, what we should do about it?
Yes, Your Honor. In terms of the standing, the invoice itself, ADAX has the burden of proving that it has standing. In the very documents that ADAX attached to its complaint, namely the invoice, it expressly states on there that the right to collect the receivables has been assigned. The reason we didn't go through in further detail in our papers is that there isn't much more to say about it. We think it's simple on its face. Their own documents have established that they have assigned the right to collect the receivables. And according to the case law that we've cited, that when you assign the right to collect those receivables, you no longer have a right to pursue a maritime lien, because the lien and the debt are intertwined at that point.
Okay,
well, when you
Mr.
look
Power,
at the...
Excuse me.
Who's going first?
You go ahead, please.
All right, this is Judge Agee again. If you look at the invoice and then the 30B6 witness's testimony, I can't determine exactly what the degree of assignment is, which I would think would be relevant to the determination of standing. If a party's made a complete assignment so that they've basically and unequivocally given up all their rights with respect to a particular object, then normally the assignor would not have standing to sue an obligor. But if the assignment is only in part, then it's an open question as to whether the assignor has retained sufficient rights to continue to have standing. So when I look at the invoice and the 30B6 testimony, I can't tell what the degree of assignment is. So maybe you can give us some further delineation of that. But if we don't know whether or not ADAX has assigned all of its rights so that it extinguishes its standing, wouldn't we have to send this back to the district court to make that determination in the first instance?
Yes, Your Honor. If the court felt that it was unable to determine on its face with the express language of the invoice to what degree an assignment was made, I think we made the point that the invoice itself to us certainly seems pretty clear. They've assigned the receivables. That is the express statement on the invoice included in one of the only exhibits. When we sought the deposition of the 30B6 witness, that witness certainly was not capable of offering any further testimony as to whether or not it was something less than a full assignment.
Well, excuse me, Mr. Power, this is Judge Keenan. Isn't it really more the testimony, though, of the 30B6 witness that it's not clear whether there was an assignment at all? That the 30B6 witness said you just couldn't speak to it. Essentially, this is something they put on their invoices, but that doesn't mean that there wasn't, in fact, an assignment. And let me ask you to also address, when you answer my question, the distinction between a real party and interest and standing. Is this really an issue of standing, or rather a question under the federal rules of whether ADAX is the party which has the right to bring this lawsuit? In other words, are they the real party in interest? I mean, the court clearly has admiralty jurisdiction. The question is, who is the real party in interest, isn't it? Whether it's ADAX or if there has been an assignment, the S&E.
Yeah, well, again, I think if they've assigned the right to collect the debt, in other words, they no longer own that right, then they no longer are the proper party withstanding to assert a maritime lien. And this is we did touch on this in our briefing, because there's been recent cases, including the cases that we've cited, is that typically when these fuel supplies are financed by third parties. When a third party finances the fuel supply, they want all the rights and remedies immediately assigned so that they can go pursue if the payment isn't made. So usually in the terms, and again, those documents were not produced, but in the terms of these agreements with the sellers, someone like ADAX, it is not atypical to have assigned the rights over, just as in the case that we cited before the court in our brief. And
Mr. Power, this is Judge Agee again. I don't want to belabor this to the exclusion of all your other arguments, but when I look at the invoice, it just says this invoice has been assigned in accordance with our legal and contractual obligations. Well, we don't have any idea what those legal and contractual obligations are and the extent to which it constitutes an assignment, which the 30B6 witness confirmed. So in that circumstance, while certainly ADAX has the burden, if we are unable to determine whether or not they're standing here, don't we have to get to the bottom of that by sending it back to the district court to make that determination on the record?
Yes, I think you would. However, I do think that the 30B6 witnesses' inability to disclaim or to make a contrary statement that the receivables were not assigned, as stated in the invoice, precludes really any further analysis into the issue. I mean, that was the point of the 30B6. If the 30B6 did not know and couldn't provide counter information and evidence against the plain language of the invoice, then we think that there really needs to be no further analysis, that it simply should be found that there was no standing based on the document itself and the statement that the receivables had been assigned.
That answers my question. I don't want to belabor this so that Mr. Power can move on.
Okay, thank you.
I'm sorry, just one more question about this, is Judge Mott. So your argument is that the other side can't enforce the maritime lien because they assertedly have no standing, right?
Yes, that is correct. They've expressly stated that they've assigned the right to the receivables.
Yeah, I know. Okay. But Addix suffered an injury in fact when it provided the vessel with fuel. It did not receive full compensation, right?
Well, Your Honor, I don't know whether they've suffered an injury in fact because it became irrelevant once the settlement agreement was made. And in fact...
No. Leave aside the settlement agreement for a minute. We're just talking about, now we're talking there about their ability to show an injury in fact. So this is prior to the settlement agreement. They didn't get paid for the fuel, right?
Yeah, well, Your Honor, again, if they assigned the receivables, they weren't supposed to be paid for the... I mean, in other words, they might have been collecting it, but they were collecting it on behalf of someone else. So then they did not incur any injury. That injury was to a third party who was the only one that would have standing.
Okay, Mr. Power.
Go ahead.
I'm sorry, Judge Motz. Go ahead, please.
No, you go ahead.
Okay, Mr. Power, see, I'm worried about you characterizing this as standing and bringing it into the jurisdictional realm. It seems to me that it is a real party and interest question under Federal Rule of Civil Procedure 17, and that the vessel, as Judge Mott says, the plaintiff, Addix, as Judge Mott says, can say, we provided the fuel, we didn't get paid. And then you come back and say, no, even though you provided the fuel, you're not the real party in interest in this case. And it would then be your burden to establish that Addix is not the real party in interest, as opposed to trying to call this an issue of standing and tag Addix with the responsibility of showing that they didn't assign it. It seems to me there's a serious burden of proof issue in terms of whether you call this standing or real party in interest, and I'd really like to have you address that distinction.
Sure. Yes, Your Honor, and I would agree with you, but for the fact that Addix itself has presented to the court what I would say is now burden shifting, is they've represented themselves that the receivables have been assigned. This isn't a case where the contract is silent. If that were the case, I would agree. I would have the burden. But here, the information itself presented to the court in the first instance by Addix, using their own document, says the receivables have been assigned. So the burden remains on them because of that fact. Now, had they not done that, I would agree with you, Your Honor.
Okay, thank you.
My countdown clock says 2 minutes. Should I continue to focus on this issue, or should I move to the issue of the settlement agreement?
Talk about whatever issue you wish to talk about.
Yes. Okay. Yes. The next issue, which would move all other issues, is whether the court has subject matter jurisdiction. We believe the case law is clear, on point, and we've referenced it in our briefs, that even assuming that once the settlement agreement was executed between the parties, which covers the debt, and the express language of the settlement agreement itself, which is Joint Appendix 138 to 141, refers to the subject matter as the debt, which is the amount that was owed under the supply agreement. So the settlement agreement also expressly states in Clause 13 that it supersedes and extinguishes all previous agreements. The agreement is governed by Swiss law. There is no reference to maritime liens or preserving liens. So therefore, we believe the case law is clear, and it must be that once the settlement was executed, consideration paid, and performance being made, that there is no longer a right by Addix or anyone else to arrest the vessel on an alleged breach of the original supply agreement.
Okay, Mr. Power, my concern with that, and this is Judge Keene again, my concern with that argument is really twofold. You've got a problem with the lien arising by operation of law, and you have the vessel not being a party to the settlement agreement. So why would we require addicts to expressly reserve its right to a statutory lien against the vessel in an agreement with another party when the lien arises separately by operation of law?
Well, Your Honor, that's a good question, particularly because it's a fiction in terms of when we say, in this particular case, that the lien is arising by operation of law. The only reason that addicts is even able to assert a lien under U.S. law is because the supply contract itself, even though it's covered by English law, says that maritime liens shall be interpreted by the law of the United States. Under the Queen of Le Mans case, if that single clause was in there, there would be no question that addicts would never have been able to even assert a maritime lien against this vessel while it was in U.S. waters. So because of that unique contract clause that addicts included in its supply contract, the terms of the contract itself are the only enabler that allows addicts to have a lien, as there is no other connection to the United States but for the clause stating that the liens arise under the supply agreement are governed by U.S. law. So addicts chose to use the supply contract to allow itself to assert a maritime lien. We were not a party to that contract either, yet the vessel was subject to those provisions. As such, we certainly should be able to rely upon any defenses that are available pursuant to us based upon the subsequent settlement agreement. So we cannot be held to the terms and conditions, including the U.S. lien clause in the supply contract, but then not be able to rely upon a later subsequent contract which replaced the supply agreement, which is the settlement agreement. My timer is telling me my time is done. Would you like me to proceed, or can I proceed to continue, or shall we save it for?
Well, let me ask my colleagues if they have any questions.
No, thank you.
JG?
No further at this time.
Thank you.
All right. Why don't we listen to what your colleague on the other side has to say?
Good morning, Your Honors. This is Lauren Wilgus on behalf of the appellee, Addicts Energy SA. May it please the Court. Before I address the appellant's arguments concerning the party in interest and the settlement agreement, I would first just like to take a step back and just talk about this action generally. The action below was commenced by a Swiss fuel supplier, Addicts Energy, seeking recovery of payment for its provision of bunker fuel to appellant's vessel. It's undisputed that Addicts supplied the vessel with the fuel bunkers on the order of the vessel's time charter, Windrose Shipping. It's also undisputed that Windrose had legal authority from the vessel's owner to order the bunkers. Addicts thereafter issued an invoice to Windrose, and Windrose ultimately made 2 small payments. Under the law, at the time Addicts supplied the fuel to the vessel, 2 claims arose. Addicts had an in rem maritime lien claim against the vessel itself by operation of law, and Addicts had an in personam claim against the charterer under the contract. Due to Windrose's non-payment for the full amount of the fuel bunkers, Addicts pursued its in rem maritime lien claim against the vessel for the remaining amount due. To pursue its in rem maritime lien claim, Addicts arrested the vessel in the Eastern District of Virginia. By agreement, the vessel was released from arrest by the deposit of cash security into the court's registry. Now, YASA does not dispute that Addicts' provision of fuel to the ship meets the requirements for a maritime lien under the Maritime Lien Act or Rule C. Instead, YASA argues that a separate settlement agreement between Addicts and the vessel's charterer extinguished any right Addicts had to foreclose its maritime lien against the vessel, which undisputedly received and consumed the fuel and was not paid. The district court rejected YASA's position concerning the applicability of the settlement agreement to Addix's in-rem claim, finding that the settlement agreement does not govern Addix's ability to pursue a maritime lien by operation of law, and Addix's attempt to secure relief by contract with Winrose does not foreclose its distinct right to relief through an in-rem claim against the vessel. The district court correctly concluded that the non-payment for the fuel resulted in an enforceable maritime lien and in-rem liability against the vessel as a matter of law. Addix has a valid maritime lien against the vessel within the meaning of the Federal Maritime Lien Act. Under the law, when a maritime lien attaches, a supplier of necessaries, which Addix is in this case, may pursue both an in-rem action against the vessel and an in personam action against any party who is directly liable under the contract. Fourth Circuit authority on this point is clear.
This is Judge Agee. Yep. I have a question there. So do we know on this record whether with this assignment, whether or not an assignment was made, whether it was limited to the contract receivables or whether it included all rights and interests, including the maritime lien? Because when I look at the discussion by Mr. Robert, the 30B6 witness, it's kind of hard to tell.
Your Honor, you're talking about the real party and interest issue here, and the notation you're talking about is in an invoice. It's just a standard clause. Mr. Robert testified that it's just a standard clause that's inserted in Addix's invoices. There's no evidence to support the proposition that Addix assigned its claim here. The evidence actually shows that Addix was the one that pursued the collection of the debt with Winrose. So again, just by the actions of the parties, it's clear that Addix, in fact, was pursuing the debt here. So they obviously had an interest.
Counsel, if I can interrupt you there, the fact that Addix may have pursued the action isn't sort of an ipsa dixit that gives it standing. I mean, the district court's own finding was that the record was not clear as to whether the plaintiff had assigned its rights, and then it determined that the plaintiff had legal standing because it had pursued these claims against the ship. But it may have not had standing or been a party in interest at any point along the way, depending on what, in fact, it assigned. Because if it assigned not only its rights under the contract, but also its maritime lien, or all rights and interests that it may have had, how could it pursue the action?
Your Honor, the burden was on YASA to show that Addix did, in fact, assign its rights here, and, in fact, there was no evidence to show that it actually did. Again, the maritime lien arises under operation of law, not under the contract. So if you just take the contract away completely, Addix supplied the vessel with fuel. The fuel was used by the vessel, and Addix has a maritime lien under the law. Again, there's no evidence.
Couldn't it have assigned the maritime lien?
There is no evidence that it was assigned here, Your Honor.
Well, I understand that there isn't, which is one of the problems I think that's created here. But what I'm asking you is, would Addix have the right to assign its maritime lien?
I suppose, yes, Addix could have, but again, there's no evidence that it did.
Okay, Ms. Wilgus, this is Judge Keenan. Let me ask you a question. To what extent are you relying on the Swiss bankruptcy proceedings and the settlement agreement? Because in the settlement agreement, Addicts and Winrose reached the disposition, and presumably, if Addicts wasn't the real party of an interest, Winrose wouldn't have entered into any agreement. To what extent are you relying on that? I haven't heard you talk about that.
Well, again, Your Honor, as I said,
or do you think that point is relevant?
I don't think the point is relevant to Addicts' in rem maritime lien under the law against the vessel. To the extent,
yes, but is it relevant? Excuse me, I don't mean to cut across you. Is it relevant to the issue of whether, in fact, there wasn't whether Addicts had assigned its claim? Is that any
I'm sorry, Your Honor. It's hard on the phone. I apologize.
No, my problem too. I apologize too. You go ahead.
I think the settlement agreement itself is entirely irrelevant to the claim here. To the extent it is relevant to show the actions of the parties. As I said, Addicts pursued recovery of the amounts due from Winrose. It wasn't somebody else. It wasn't. Addicts didn't say, we're doing this on behalf of some other party that we assigned our rights to. None of that has been established in any of the emails, any of the documents, any testimony in this case at all. What, again, it shows is that the evidence actually shows that Addicts pursued its right to collect the debt with Winrose. It did so in negotiations. It did so with the settlement agreement, etc. There's no evidence whatsoever that any other party came in here and said, wait a minute, this is actually my right to pursue recovery of this amounts due. So to the extent the settlement agreement is relevant at all, again, it just shows that Addicts, in fact, was the one who was pursuing the debt here.
Okay, thank you.
With respect to the settlement agreement, again, as I stated, the Addicts' in rem claim against the vessel does not arise under the supply agreement or the settlement agreement with Winrose, but by operation of the law. Thus, whether the settlement agreement preserved Addicts' right to a maritime lien is legally irrelevant here. Contrary to YASA's misrepresentation, the plain language of the settlement agreement contains an absolute reservation of Addicts' rights under the supply agreement under both Clause 3.2 and 4.1 of the settlement agreement. Your Honors, with respect to the extent appellants are going to discuss any assignment of any rights to collect the lien from the Cargill assignment, which may come up. Again, the settlement agreement between Addicts and Winrose is wholly irrelevant to the in rem claim here. But even if the settlement agreement was relevant, appellant's argument concerning the Cargill assignment fails because there's no evidence whatsoever that Addicts acted in bad faith or in a manner otherwise inconsistent with its express rights under the settlement agreement. The agreement actually reserved Addicts' sole right to determine the validity of the Cargill claim. And Addicts' witness, Mr. Robert, testified that shortly after executing the settlement agreement, Addicts sought information concerning the Cargill assignment from Winrose, was insecure about that assignment because Winrose did not provide all of the information that Addicts was seeking, and Addicts exercised its right under the settlement agreement and determined that Winrose failed to provide satisfactory information regarding the claim, and Addicts did not, in fact, accept that assignment. And finally, to the last point, to the extent appellant's argument potentially regarding any sort of double payment issue may arise, that was resolved. Addicts executed an assignment of its debt against Winrose in the Swiss bankruptcy and actually assigned YASA its right, title, and interest to any debt owed by Winrose. We checked with our client concerning the status of the Swiss bankruptcy proceeding and understand that nothing has actually moved forward with that as of August when I checked with them.
Hey, Ms. Wilgo, since you're winding up, could you clarify for us what is your position with regard to the assignment language on the invoice? Did ADEX assign its right to collect the invoice? Are you saying it did not assign it, or that the record does not prove whether it assigned its right? In other words, are you taking a categorical stand that ADEX did not assign its right, or are you simply saying the record doesn't show that?
Your Honor, the record, the evidence in the record does not show that ADEX assigned its right. As I said, the record does in fact show that ADEX itself pursued collection of the debt through negotiations with Windrose, and also it pursued its rights against the vessel here. There's no evidence in the record whatsoever that ADEX or any assigned its rights at all, and in fact, no third party has come in at all and said, you know, wait a minute, this is actually our right to collect this debt. We produced thousands of pages of documents, which included email correspondence and contracts, et cetera. And again, the 30B6 witness. And again, there's no evidence whatsoever that anybody except ADEX had a right to pursue its debt, the debt here. And so again, there's no evidence in the record that any other party.
Hi, this is Judge Motz. I'm not clear on what your answer was to Judge Keenan. Are you saying your client didn't assign it, or that the other side has to prove that you assigned it, and they haven't on this record?
Your Honor, I'm saying that this issue concerns whether ADEX is the real party in interest in this case. The burden was on YASA to show. ADEX was not the real party to pursue the claim here. YASA did not meet its burden because there is no evidence in the record that ADEX assigned its right under the fuel invoice.
Okay, so when the district court found as a fact that it was unclear whether your client, ADEX, had assigned the lien, you think that's of no consequence, that doesn't have to be determined. Is that correct?
Your Honor, I'm saying that there is no evidence that anybody except for ADEX is the real party in interest in this case.
Well, you and I both know what the district court said. It said that as a factual matter, it was unclear whether ADEX had assigned the lien. But it said ADEX assigned that issue is not material to ADEX's right to enforce the lien.
Yes, Your Honor.
Is that your position?
Yes, Your Honor.
And the reason it's not...
No, go ahead.
No, go ahead.
Along this line, this is Judge Agee, as I understand the opposing counsel's brief, they represent, you tell me if this is incorrect, they represent that they requested the district court to order the production of the assignment documents, assuming there were some, and the district court denied that motion for tardiness. Is that correct?
Your Honor, yes. YASA argued the district court did not afford it an opportunity to brief the issue concerning the party in interest standing issue. Yet, you know, YASA Shipping actually was given ample opportunity to raise the issue during discovery. It did not. It could have sought information in its discovery request. It did not. It could have sought to compel information concerning this particular issue. It did not do that either.
Pardon me for interrupting, but my understanding, which may be incorrect, was that the opposing counsel has represented that it did request this information with respect to an assignment, which would seem to answer the questions we have today, and that request was denied. Is that factually correct?
YASA was given an opportunity to raise the issue in its opposition to Addex's summary judgment motion. The district court considered the request and rejected the request.
So if this is indeed a question of standing, however that interplays with a real party in interest, isn't the court obligated to assure itself that it has the subject matter jurisdiction required for standing?
Yes, Your Honor. I believe that the court did, in fact, satisfy itself that that there was a plaintiff did have the legal standing to maintain the claim under the Maritime Lien Act.
And this goes to the fact that the district court has said it wasn't material as to whether Addex assigned the materials, the receivable. Is that right? Because
yes, Your Honor.
It suffered an injury in fact when it provided the vessel with the fuel, but did not receive full compensation.
That's correct, Your Honor. Under the Maritime Lien Act, a party providing necessaries to a vessel on order of the owner or a person authorized by the owner has a maritime lien on the vessel and may bring a civil action in rem to enforce the lien and is not required to allege or prove that credit was given to the vessel.
So that's the standing that they have. That's standing.
Yes, Your Honor.
Okay.
Under the law.
Under the law. And so when the other side maintained that you had assigned the receivables, what they were doing, as Judge Keenan said a few minutes ago, I'm just catching on, is that they're making an argument that your client is not the real party in interest, right? Because they've now assigned.
That seems to be their argument. But again, there's no evidence. A notation on an invoice is not evidence that there was an actual assignment. There's actually no evidence.
That's not a question of jurisdiction, though.
Right.
Because, okay.
That's correct, Your Honor.
Do you have anything else you want to tell us?
No, Your Honor. If there are no further questions, Addex rests, and thank you to Your Honors for your time today.
I just want to be sure that my colleagues have no further questions. Judge Agee?
No further.
Judge Keenan?
Nothing, thanks.
Thank you very much, counsel.
Thank you.
I think the other side has reserved some time for rebuttal. If you have any rebuttal, we'll be happy to hear it.
Yes, Your Honor, I do have some time for rebuttal. I would like to make the point that I think the district court, despite saying that he couldn't determine one way or the other whether there was an actual assignment of the right of the maritime lien. Maritime liens are assignable under U.S. law. Assuming there was a lien that existed at the time the fuel was supplied, under the terms of the agreement, we are arguing, the express terms of the invoice, is that lien, we believe it was assigned because that is typical of the factoring agreement that is in place with these banks that lend money. The banks themselves want to hold the rights to the liens and the rights to collect the debts. That is exactly what was determined in more than 30 cases around the country over the last 4 years, including the Barcliffe versus MVP Blue case, that when Addex, who is the seller, finances the purchase of the fuel, immediately upon supply, under the financing agreements, the maritime lien is transferred over, including the right to collect the debt. In other words, the lien follows the debt because the banks want to have that right. So we do
if I could interject a quick question. This is Judge Agee again. The Addex could have bifurcated its rights. It could have retained the maritime lien and assigned the receivables rights, couldn't it?
No, absolutely not. That would allow that would create the absurd result that we have detailed in our brief. In other words, you would have Addex go arrest the vessel, collect the full amount of the lien, which is the fuel supply price, and then you would have the bank going and chasing the purchaser for the other amount, thereby effectively paying twice the value of fuel from two different parties. This is exactly what the 30 cases in the OW group litigation around the country have ultimately resolved, that there is no two claims. The two claims, in rem and in personam, are intertwined because you cannot go and chase two different parties, one for an in rem claim and the in personam for an in personam claim, and then have them to pay two different people, for example, addicts who claims to hold the lien and the bank who claims the right to collect the debt. So that is not a possible scenario, which is why
they have brought the in rem claim and collected. Wouldn't the obligor have an absolute defense that it already paid once?
Yeah.
No, because remember,
pay twice.
Yeah. Remember, remember the obligor is Windrose. Windrose would not have paid once. It would have been another party that would have paid. So that's exactly the problem here, is that when you arrest a vessel claiming that it's totally unrelated to the contract, and or in this case the settlement agreement, that you have an independent in rem claim that you could pursue and collect fully, the obligor is not the vessel, the obligor is Windrose. The vessel is merely the subject of an in rem claim. There, in no way can you consider the vessel an obligor. It is simply by operation of U.S. law. And again, U.S. law only applies here because it was included in a contract to which the vessel owner was not a party, which again raises serious questions as to whether U.S. law should apply at all, since there were no connections to the supply of fuel in the United States between U.S. entities or U.S. flagged vessels. But that being said, it is imperative, and which is why we understood the language of the contracts to clearly mean that the receivables, including the debts and the rights and the liens, if any, were assigned. That's what it says on the invoice. We take Addict's word for it.
But aren't you, Mr. Powell, aren't you also required to take Addict's word and its agreement in this case that it does not have a right to double recovery? It just seems to me that what you're trying to say is because what the 30B6 witness said was essentially a boilerplate statement without any other evidence, you're trying to transform that into an assignment when we have no evidence as to who was the assignee. We don't know anything, but we do know that the Swiss bankruptcy proceeding was settled as to Addicts and Windrose. Windrose agreed to pay a lot of money and suggesting that there wasn't as an assignment. So there's more evidence that there wasn't an assignment, at least circumstantially in this case, than there is that there actually was an assignment. So,
I disagree.
I'm just troubled that you're telling us what banks usually do in other cases when this record is just really bereft of evidence of an assignment, other than that one boilerplate statement that the district court didn't find sufficient to carry the day.
Well, Your Honor, I mean, that receivable in the express language, that invoice in the express language on there is really no different than the contract, which says, well, an assignment has been made. I mean, if that document was produced, I don't think, the court would say there's no evidence that an assignment's been made. So we have one contractual document, which is the invoice, which says receivables were assigned to somebody else. So I do think there is ample evidence on the record that when you assign a receivable, I believe you cannot retain the maritime lien. I do not believe as a matter of law that is possible. So you must infer, absolutely must infer, by the express language used by Addicts itself in its own invoice, submitted at the outset of this arrest action, that it has assigned the receivables and along with it, under operation of law, the maritime lien. Because you cannot retain a lien and assign the right to collect the debt.
Well, I don't understand how we could just assume that. It would seem to me at least it would be your burden of proof. I'm not sure that your argument goes anywhere, but at least you would have to establish it. The district court said you hadn't established it.
Well, I think the court said he didn't know one way or the other because he hadn't made a legal determination.
That means you haven't established it. I don't know how do you translate that as you have established it.
Well, again, the burden is not on me to prove a negative. The document itself speaks for itself. When you transfer a receivable to another party by operation of law, I don't have to prove it. It is the law requires it. that the lien follows the debt. 100%. It cannot be otherwise. Otherwise, it will lead to the absurd result where two parties are being chased to pay the same debt to two different people, which is exactly what the OW said.
Yeah, but Mr. Power, this is Judge Keenan. Well, isn't it absurd for us to accept the proposition that Windrose would agree to pay Addicts $300 and some thousand if Addicts had already assigned that lien to a third party? I mean, that's what it seems like your argument's built on the house of cards.
Yeah.
If you want us to believe that Windrose agreed to pay that money, even though Addicts had assigned the lien to a third party, why is that a reasonable proposition?
Well, Your Honor, it's exactly the same reason for Windrose believed that when it was paying under the settlement agreement, Windrose had no reason to believe that Addicts would go out and arrest the vessel seeking the same debt. In other words,
right.
Windrose had already...
Yes, but Mr. Power, if Addicts had already assigned it to a third party, why would Windrose be agreeing to sell out $300 and some thousand to someone who wasn't the real party in interest?
Well, remember, just because you assign a lien and the right to collect the debt, that wasn't something that Windrose was looking to satisfy its obligation to the entity that it entered a contract with, right? Windrose could reasonably believe, and again, I don't know if the representations by Addicts were truthful. Certainly they represented that the debt was clear and we were not going to pursue anything and we've released you so long as you pay us the $20,000, we won't take any other action. They took action even before the settlement agreement was breached. So, again, I wasn't there. I didn't negotiate. I think it's pure speculation, and I don't think for this particular case there should be any great focus in what's going on in the Swiss bankruptcy proceeding or what Windrose might have believed was the basis for the rights for it to enter into a settlement agreement with Addicts. Addicts may very well have represented it has the authority to enter into a settlement agreement to clear the debt and extinguish the lien. And again, it seems clear that that's probably what they did represent because Windrose agreed to enter into a settlement agreement and begin paying money. When the vessel was arrested prior to the breach of the settlement agreement, right, immediately after the $20,000, I think what we see here is that Addicts has acknowledged that the settlement agreement is absolutely governing over whether or not there's a maritime lien because they reduced their maritime lien claim by the $20,000 paid under the settlement. So, again, I really think that the settlement agreement is the penultimate contract which the court should look to, and all the rights that are available to Addicts, to the extent they weren't already assigned, should be purely governed by the settlement agreement.
Okay, let me just follow up on one aspect of my earlier question, Mr. Power. The assignment language was on an invoice that was issued to Windrose. So Windrose knew when it was settling and agreeing to pay $300 and some thousand that this assignment purportedly had been made. And you're saying that Windrose was agreeing to pay $300 and some thousand, notwithstanding the fact that the invoice that was the subject of the Addicts-Windrose dispute had this language saying that an assignment had been made.
Yeah, because I think of course the Addicts had the apparent authority to make a settlement under this, whether it was on behalf of itself or someone else, it's irrelevant. The Addicts had the apparent authority, just like Addicts states that the charterer, not the vessel owner, had apparent authority to bind the vessel. It's no different. There are people that represent themselves to have authority to settle a debt, right? So Addicts could simply be the agent on behalf of the person that had assigned the receivables and the lien to exercise the right to enter into a settlement agreement to settle the debt. We don't know that either.
So I'm going to sell out $300 and some thousand because, hey, this plaintiff might actually be the real party in interest. Could be, despite that assignment language. That just seems to be a very impractical.
Again, I think it didn't matter at the time, and it makes sense that it wouldn't matter to Windrose if Windrose went into a settlement agreement, okay, such that settlement of the agreement would bind not only Addicts, but any entity in which addicts had authority to act as agents who had the right to collect the lien or the debt, again, it wouldn't matter. There's no one suggesting that addicts didn't have apparent authority to settle a debt if, in fact, it itself was owed the debt, or that debt was owed by the very party that it assigned the receivables to. So I wouldn't read anything into the fact that Windrose thought it was appropriate under the circumstances to settle with the party that it had contracted with, right? It has nothing to do with an acknowledgement, implicit, express, or otherwise, that Windrose was admitting that the assignment of a receivable was not made for the maritime lien to someone else. Only that debt, that debt agreement, that settlement of the debt precluded any further action to collect the debt or the maritime lien either by addicts or any other party.
Counsel, can you give me a case which supports your view that an assignment of the receivables automatically assigns the maritime lien? You haven't briefed this, so there's nothing in your brief that says that.
Yeah, I think certainly the Barclays versus MVD Blue case, because they looked at the language of the assignment, and they said when you assign the debt, you assign the maritime lien goes with it. So we did.
They say that it automatically, any assignment of the debt automatically assigns the maritime lien. That's what I'm looking for. A case that says that.
Well, I think it's just implicit in these cases. I think
maritime lien is a very peculiar animal.
Well, no, it is a peculiar animal, but what has been universally held by the courts is that they're not two separate claims. You can't pursue the in rem independently from an in personam and collect on both claims. The claims intertwine.
Yeah, but that doesn't necessarily mean that assignment of one, the assignment of the receivables, means that you've assigned the other. You can't collect twice, to be sure. Anyway, thank you. I appreciate your answer. My colleagues, do you have any further questions? Okay. I think you've well exceeded the time for your rebuttal. Thank you very much, both of you. We appreciate your arguments.
Thank you, Your Honors.
We will adjourn court, and our clerk will get us ready for the next case.
Okay. Thank you.
Thank you, Your Honors. Have a nice day.
The court will take a brief break before hearing the next case. I will be calling all the judges back momentarily for the next case. Thank you.
Thanks so much.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Good morning, everyone. We are happy to hear argument in number 18-1761, Alvarado versus Barr. Counsel, if you would identify yourself before you start speaking, that would be helpful to us. Thank you.
Thank you, Your Honor. This is Brianna Carlson, and may it please the Court. My colleague Benjamin Osorio and I represent Marta Alvarado, and Allison Rivas Alvarado, the petitioners. There are currently 3 questions before this Court. First, whether the immigration judge and board impermissibly placed the burden on the petitioners to demonstrate no fundamental change in circumstances had occurred. Second, whether the Department of Homeland Security met its burden to rebut the presumption of future persecution. And third, whether the petitioners' due process rights were violated when the immigration judge failed to give reasoned consideration to their documentary evidence. To the first question, as to whether the immigration judge impermissibly placed the burden on the petitioners to demonstrate no fundamental change in circumstances had occurred, this is a question of law and is therefore reviewed de novo. Additionally, this is a threshold question. If the court does agree that the burden was impermissibly placed on the petitioner, then a remand is necessary. Where an applicant for asylum demonstrates past persecution and is found to have been persecuted in the past, they are entitled to a presumption of future persecution. The burden then shifts to the Department of Homeland Security to rebut that presumption by a preponderance of the evidence. The department can rebut that presumption. Yes, Your Honor.
Excuse me, can I just interrupt you at the outset? Because does your argument on this point depend upon whether we find that the burden of proof has been switched, or is that one of your arguments along this point? And your second point is, even if the IJ didn't switch the burden of proof, it erred in its analysis.
It's the second.
In other words, is burden of proof necessary to this argument, the switch of the burden of proof?
So the burden of proof, if it was on the petitioner, then we don't have to get to the second question of whether or not the department met its burden, if it was impermissibly placed on the petitioner in the first instance. However,
I understand. You go ahead.
But yes, to the second point is exactly as you stated, that the department did not meet its burden. And so the department can meet its burden by a preponderance of the evidence if they are able to demonstrate that the applicant for asylum can safely relocate in its country of origin, or a fundamental change in circumstances has occurred. Here, the immigration judge impermissibly placed the burden to demonstrate that a fundamental change in circumstances had not occurred on the petitioner. We know this because in his oral decision, the immigration judge made factual findings that Ms. Alvarado did not know whether her family continued to be threatened or extorted by the 18th Street Gang. Later in his decision, he specifically states, the respondent has failed to carry her burden in establishing that she will continue to face persecution if she returns to El Salvador. He goes on to note in a discussion of the facts, it appears to the court that there is no indication that the family continues to pay extortion money. There is no indication that the family continues to suffer threats at the hands of the 18th Street Gang or any other gang. We can see from his coloring of these facts, there is no indication that the immigration judge is expecting the petitioner to demonstrate that the threats and the extortion are ongoing, rather than the Department of Homeland Security to demonstrate that something has changed, that the threats have stopped, that there is no longer a risk to the petitioner's life or safety. He goes on to explain, again, stating that she failed to carry her burden, that principally because the group which she belongs, the particular social group, family members of Maria Alvarado Rosa, are no longer being persecuted, at least so far as the evidence of this case has indicated. Again, he's placing the burden on the petitioner to demonstrate that that her family is continuing to be extorted and threatened by the 18th Street Gang, rather than the burden on the Department of Homeland Security to demonstrate that those threats are no longer continuing. when the judge is viewing the facts from the position that the threats are going on, when a respondent is entitled to the presumption, the immigration judge must view the facts from the view that the persecution is continuing. Here, the expectation that Ms. Alvarado demonstrate that it is continuing is entirely contrary to that presumption. Instead, the Department of Homeland Security was required to demonstrate that some type of fundamental change had occurred, that 18th Street Gang was no longer in the area, that somehow her family was no longer being extorted or threatened. This brings me to the second question, which is whether the Department of Homeland Security met its burden to rebut the presumption of future persecution. This is a question applying facts to law and is therefore reviewed de novo under recent Supreme Court precedent in Guerrero-Las Brea v. Barr. As previously stated, the immigration judge found Ms. Alvarado had no knowledge of whether the 18th Street Gang continues to threaten and extort Ms. Alvarado's family in El Salvador, which makes it unclear whether Ms. Alvarado would continue to be persecuted. Under Ortiz-Cruz and Dong v. Sessions, it's clear that where an immigration judge finds that the record is unclear as to the evidence of whether the threats continue, the department must show that their view of the evidence is the most reasonable view, and the immigration judge must give a reasoned explanation as to why the government's view is the more convincing and plausible inference pointing in that direction, is the most convincing view. Here, we have no interest in disturbing the immigration judge's factual findings. The immigration judge correctly concluded that it was unclear, based on the evidence, whether the family was still being threatened and extorted. Instead, the immigration, regardless of that finding, went on to find that a fundamental change in circumstances had occurred without giving a reasoned explanation. In Ortiz-Cruz, this court stated, it will sometimes be difficult for the government to prove that an individual in another country no longer poses a threat, but that is consistent with the presumption. It puts a thumb on the scale for applicants who show past harm. Here, the immigration judge, in considering the evidence, must assume that the persecution is continuing and then consider the evidence from that point of view. And there is no evidence in the record that should have overcome that presumption. Much like in Ortiz-Cruz, there was a lack of evidence of persecution one way or another.
Well, that's not exactly right. The record here shows that the applicant both said that she testified several times that she was in contact with her family, but she hadn't heard them say that there was continuing threats. And then she also said, of course, that she might not have heard because they wanted to spare her. That isn't the situation that we had in Ortiz-Cruz, is it?
No, Your Honor, but it is similar to the situation in Dong v. Sessions. In Dong v. Sessions, the petitioner had been in constant contact with his family, and the last time they had informed him that the police were searching for him was in 2009. His individual hearing took place 2 years later in 2011, and while he was in constant contact with his family, they never mentioned one way or the other whether the police were still looking for him. And in that case, this court found that that was not enough to rebut the presumption. Similarly, here, in addition to the unclear evidence as to whether or not the persecution was continuing against the family, we have expert witness testimony that says that it's likely that the persecution would be continuing. When asked whether, under what circumstances the expert witness could imagine a gang that was extorting a family would stop extorting a family, the expert witness was only able to give 2 examples. He imagined that a gang member would have to plead the family's case to the gang to get the gang to stop extorting the family, or the family would have to relocate to a gated community, a wealthy area where the gang wouldn't have access to them. We know from record evidence that Ms. Alvarado's mother still lives in the same home, and there is nothing in the record that indicates that they became friends with a gang member and that gang member would have pleaded their case. So there is affirmative evidence, according to the expert, that it's likely that the gang would continue persecuting the family. This is similar to Ortiz Cruz in that case, the expert witness noted that while it had been 15 years since the persecutor had contacted the petitioner, it was likely, given the nature of domestic violence cases, that he would, once aware that she had returned to her country, would pursue her. And so, again, this is not enough evidence to rebut the presumption. Additionally, the court's indulgence. So where we have no record evidence that is clear as to whether or not the family is continuing to be extorted and continuing to be threatened, and we have affirmative evidence on the record from expert witnesses that state that it's likely that once the gang has started extorting a family, they will continue to extort a family. Additionally, we have significant documentary evidence that shows there's been no fundamental change in the country. The gangs have not been excluded from the country. The police are not suddenly protecting people from gangs. There's no documentary evidence suggesting that there's any type of a change in circumstances. The department simply cannot meet its burden.
Hey, Ms. Carlson, this is Judge Keenan. Do you agree that a finding as to fundamental change of circumstance is a finding of fact rather than a legal conclusion?
Your Honor,
doesn't Ortiz Cruz pretty much say that?
Your Honor, Ortiz Cruz predates the recent Supreme Court decision in Guerrero-Las Bria v. Barr, and in that, it reviews this idea of questions of applying facts to law. And there, the Supreme Court held, which was contrary to many circuit court decisions, that when you're applying the law to facts, it's actually a question of law instead of a question of fact, and therefore it's deserving of de novo review.
Does that make any difference in terms of the shifting of the burden? Does the interplay of the Supreme Court case with Ortiz Cruz have any practical consequence when you are attacking the fact that the IJ shifted the burden to the petitioner?
So, well, Your Honor,
does that help your case or not?
Yes, it does help our case. I think it absolutely helps our case. I think if you consider the fact that Ortiz Cruz was reviewed under a much more deferential standard, and still, given the evidence in that case, the court found that remand was necessary and that the department did not meet its burden. When you're looking under de novo review, which gives this court much more latitude to review the evidence in the case and the factual findings and apply the law to those factual findings, then yes, it's highly in favor of finding that the department did not meet its burden. So, given that it's de novo review, and in Ortiz Cruz it was substantial evidence, this court is well positioned to be able to find that the department did not meet its burden, and to remand this case with instructions to grant asylum. Given that the department did not meet its burden, there has been no fundamental change in circumstances, and Ms. Alvarado is entitled to asylum. Which brings us to the last issue before this court, which is whether the petitioner's right to due process was violated when the immigration judge failed to give reasoned consideration to her documentary evidence. This is a question of law and also reviewed de novo. Ms. Alvarado must not only demonstrate that her due process rights were violated, but also that she was prejudiced as a result of that violation. Here, the immigration judge did not have what was titled Exhibit 4, which is the petitioner's evidence in support of her application. It's several hundred pages of exhibits that he did not have the opportunity to review until about halfway through the hearing. At that point, he did not pause the hearing to take time to review that evidence. Instead, he continued on with the hearing and then gave his decision immediately following testimony the same day. While the immigration judge is not required to address every piece of evidence in the record in his decision, he is required to announce his decision in terms sufficient to enable a reviewing court to perceive that they have heard and thought and not merely reacted. The immigration judge is not free to simply pass over evidence without ever reviewing it. That's under Ai Hua Chen v. Holder. It's a decision out of this court. Additionally, a wholesale failure by the immigration judge and the BIA to consider evidence of country conditions constitutes reversible error under Rodriguez-Arias v. Whitaker. The board incorrectly found that the immigration judge's actions to efficiently conduct court proceedings and timely decide the respondent's case were reasonable and did not violate the respondent's due process, and that no prejudice had occurred as a result of the immigration judge's failure to review the evidence. Your Honor, I see that my time is concluded. Thank you. If I may briefly conclude.
Sure.
My colleague will address the prejudice that Ms. Alvarado faced as a result of the immigration judge's failure to review her evidence. Thank you.
Hello?
Yes, ma'am. Your Honor, may I proceed?
Yes. We're waiting.
Good morning. Good morning. May it please the court. Beats LaFleur on behalf of the respondent. Petitioner's own testimony in this particular case was both conclusive and unambiguous under Ortez that the threat stopped, thereby showing a change in country conditions and rebutting the presumption of a well-founded fear of persecution. The court looks at page 191 of the record. The petitioner stated, quote, she hasn't received any more letters asking her for money, close quote. This factual testimony is conclusive and unambiguous. It complies with Ortez's holding and thereby rebuts the presumption of a well-founded fear of persecution. If the court looks at the entire body of the transcript of the merits hearing and the IJ's decision and the board's decision, it's clear, conclusive, and unambiguous that the burden of proof began with petitioner, shifted to the government, and then at the very end of the hearing, the IJ gave the petitioner and his counsel, and her counsel an opportunity to establish independently a well-founded fear of persecution. On page 136 and 138 of the record, the IJ clearly states it is your burden of proof to demonstrate that the harm constituted past persecution. The attorney acknowledged yes to this. The petitioner had the same attorney throughout the entire pendency of proceedings. At page 162, direct examination is done. At page 189, the judge says it's important to the petitioner's case to be able to say definitively whether she continued to receive threats or was harmed. At that point, the judge does acknowledge on page 190 of the record that at this point, I simply don't know. So let's go and ask her specifically. And on page 190, the petitioner says, the question is posited, is that your testimony that there's no further threats? She answers yes. On 191, the very last sentence at the bottom of the record, is where she says, quote, she hasn't received any more letters asking for money. This is the conclusive testimony that the agency relied on to permissibly establish a rebuttal to the presumption of a well-founded fear of persecution.
Okay, but Mr. LaForte,
yes, Your Honor.
Didn't the petitioner also say that her family wouldn't have told her about any threats because they wouldn't want her to have worried? And don't we have to take that into consideration in determining whether the future threat evidence was unambiguous?
Yes, Your Honor, but that occurred before. This testimony was a direct question. It was conclusive at that point. At 193...
but we don't cherry pick. We consider the whole record, don't we?
Yeah, yes, Your Honor, you do. And in doing so, it is clear to keep in mind that the IJ rendered an oral decision. The board comes in and refines it, sort of cleans it up, if you will. We didn't hear any citations to the board's merits decision regarding the rebuttal testimony from opposing counsel. Here at 193, Your Honor, all parties go off the record. When they come back, the IJ says the respondent seeks any one of several possible alternatives to present an affidavit from the mother or a letter, to seek a plausible alternative explanation. This seems to be a tacit acknowledgement from all parties that the government at this point in the hearing has satisfied its rebuttal burden. And now,
Mr. LaForte, what about the record at 192 where the petitioner says her mother hasn't told her anything, maybe not to worry me, but she hasn't told me? So this wasn't just an isolated comment on her part. She's carrying through with that position as late as page 192 in the record.
That's correct, Your Honor. The question is whether or not that usurps her conclusive testimony on at the bottom of 191 that she hasn't received.
Exactly. She qualified it a page later by saying she hasn't told me anything, maybe not to worry me. Doesn't that render it inconclusive, the prior testimony a page earlier?
It doesn't, because right before closing, the IJ expresses his concerns and gives a warning and says, even though the petitioner suffered past persecution, probably she probably faces a change of country conditions because she's no longer facing any threats. And at that point, in closing, the petitioner's counsel says, even if we say that the past persecution was rebutted by a change in country conditions, then we would still argue an independent establishment of a well-founded fear. The government, on page 232, the government puts forth no rebuttal evidence. That was petitioner's counsel's closing. So looking at the entirety of the record, Your Honor, you will see that there was a permissible burden, a shift in the burden of proof once past persecution was established to the government to rebut. And at that point, there's an acknowledgement. Even there was a concern expressed by the IJ prior to closing and an acknowledgement by opposing counsel that there's a strong possibility that there's a rebuttal, but we're going to take under the federal regulations, we're going to make an attempt to establish an independent, well-founded fear. That's not an impermissible burden shift. In fact, if we take a look at in the body of the testimony, at least 4 times the petitioner says that she speaks to her mother every day and her mother has not said anything about a threat. On 151, she says she hasn't said anything about any threats. On page 181, she says, I don't know of any threats. On page 190, she says there are no further threats. And on 191, she says she hasn't received any letters. Based on that, the IJ in its decision says on page 95 that I find past persecution. On page 96, the IJ shifts the burden to the government. Because the petitioner suffered past persecution, she benefits from the presumption, and now the presumption can be rebutted by the government. on page
okay,
97.
Mr. Laporte, this is Judge Keenan again. Let me ask you another question, because we have the IJ's specific finding here that Alvarado was credible, and the IJ didn't qualify that in any respect. So,
that's correct.
So don't we have to then accept the fact that she was credible, including her statement that her family may not have told her this to protect her and not to worry her?
Right, but in doing so, we also have to take as credible her definitive and conclusive and unambiguous statement that she hasn't, when she says my mother hasn't received any more letters asking her for money. That it does. If we
if we accept both of them as credible, we don't have a definitive response on this. And if you go look at what we said in Ortiz Cruz, then we would have to go with her. There is no conclusive. I mean, you keep saying that. You keep calling whatever you want to call conclusive. But you've just acknowledged there's also other testimony from her
right,
who
Your Honor,
the IJ found credible. Sorry. Go
right,
ahead.
Your Honor. On the first point of Ortiz Cruz, the facts of Ortiz Cruz are distinguishable from our case. The government's rebuttal was based on an inference. That is not the case here. Here, it's based on actual testimony. That's different than Ortiz Cruz. You're correct. Ortiz Cruz is the presidential pathway to deciding this case in its holding.
Did you listen to the my questions with your colleague?
Yes,
Did
yes,
you
Your
listen
Honor.
to that part of the argument? And I think you recognize that that's the point I made with her. This isn't identical to Ortiz Cruz, but Ortiz Cruz is now circuit law, and we are guided not only by the actual facts of Ortiz Cruz, but what the holding was and what the principles are there, aren't we?
Yeah, yes, Your Honor.
Okay.
I think in this particular case, like you said, we have to look at the entire body of the merits hearing. And we can't just take an isolated portion. We can't ignore the attorney's concluding argument that acknowledges that there's a possibility that the government rebutted the presumption by establishing change country conditions here. I think regarding...
Counsel, this is Judge Agee. If we assume you're correct up to this point, how do you account for the impact of the expert witness's testimony?
The expert witness doesn't impact the disposition of the case at all. On page 197, the IJ correctly states that the expert won't know if there's current extortion. So it doesn't really matter what the expert says here. The key issue is whether or not there was continued extortion after the petitioner left El Salvador. So the expert didn't opine on that. The IJ was correct by noting that, and there was no pushback or rebuttal by either the government or petitioner's counsel in that regard. So to answer your question, Judge, that the expert doesn't carry any weight regarding how the case is decided. Looking at the board's decision, the board came in and clarified, refined, cleaned up, if you will, the IJ's oral decision by correctly citing the regulation and the salient parts of the transcript at 180 and 181, 190 and 191, that the well-founded fear presumption was rebutted. The burden shifted over to the government, and the government successfully rebutted it by establishing changed country conditions. Now, shifting over for a second, I want to clarify a point to the court that regarding Guerrero. Guerrero has no effect on this case at all. Guerrero was not a ruling about the standard of review. That's at page 1069 of the Supreme Court's decision. Guerrero only dealt with the meaning of the question of law as it's used in 8 U.S.C. 1252. Our case has nothing to do with 1252. The court is, as Your Honor has pointed out, is bound by Ortiz Cruz, and that's a substantial evidence burden of proof here. De novo is not the correct burden. Guerrero had no effect on the courts, on the court applying a substantial evidence standard to the board's ruling on whether or not the government successfully established its rebuttal burden of proof. Having said that, going back to the transcript, looking at the entirety of the transcript, one piece of regulation that was in play was 8 CFR 1208.13. That even if, and this court further stated in Goering versus Lynch, that's 667 Federal Appendix 389 at page 390, that once the rebuttal burden is established, the burden then shifts back to the petitioner to independently show a well-founded fear. I think this is important because, as we said, after the judge at 189 says, it's inconclusive. We need to find out definitively if there were ongoing threats. He asked the question, it was answered. We move down when the parties go off the record at 193 and come back on. At that point, the comment by the IG indicates that either there was an acknowledgement that not only did the burden of proof shift to the government, but that the government successfully established rebuttal. And now it is up, the IG is giving the petitioner an opportunity, one last opportunity to either independently establish a well-founded fear or rebut the rebuttal by offering a plausible alternative. But at 197, the IG acknowledges that the expert is not going to know, is basically useless because he's not going to know if there's current extortion. So I think it's important to consider it in its entirety, not only the transcript, but the IG's oral decision and the board's refined decision citing the correct piece of the regulation at 8 CFR 1208 and citing the salient pieces of the transcript that's in accordance with Ortiz. It's a conclusive and unambiguous piece of testimony. So looking at it in its entirety, again, giving opposing counsel's concluding testimonies, closing arguments in that particular case, not only establishes a permissible burden of proof shift to the government, and then again back to the petitioner to independently establish it, but it also acknowledges that there is a possibility that the government established its burden of establishing the rebuttal to petitioner's primary presumption. Your Honor, if the court has no other questions, I would like to briefly conclude.
Thank you. That's fine.
As the government mentioned, Ortiz Cruz is the presidential pathway to deciding this case and its holding. Government's position is that the petitioner's own testimony on page 191 of the record, along with page 151, 181, and 190, particularly where petitioner says she has not received...
Counsel, I thought that this was... Counsel, I thought you were concluding instead of repeating your entire argument.
Yes, Your Honor. This testimony is the government's position that under Ortiz is conclusive and unambiguous. It shows a change of country conditions, thereby rebutting the well-founded fear presumption in this particular case. Thank you.
Thank you. Do we have some rebuttal?
This is Ben Osorio. Yes, Your Honor.
You may proceed.
Thank you, Your Honor. If it may please the court, Ben Osorio also with Ms. Carlson for the petitioners. First off, I just want to say that I don't think the court can ignore the first issue, the burden shifting, and that's still a threshold issue that we believe on its own would merit remand.
Can we pause for a second? Mr. LaForte just dropped off the line, and I need to get him back on the line.
Yes, ma'am.
Okay, we're good to go.
Thank you. So we would say that even if the court does not adopt a de novo standard, that even under the substantial evidence standard, Ms. Alvarado would succeed. However, it's a little perplexing. Respondent concedes that 8 U.S.C. 1252 is the governing statute for Carrillo Las Barrias, but that's also the governing statute that gives this court jurisdiction over removal orders. So our argument is that it would be applicable in this case. Also, my closing statements during trial aren't evidence, and I'm not the finder of fact. The immigration judge is, and counsel is permitted to argue in the alternative. So I don't think that my statements can be used as evidence in this case. Respondent seems to want to make a bunch of inferences that aren't actually in the record. The IJ is required to make explicit findings of fact, and that hasn't occurred here. And so we can all sit guessing, well, the IJ might have thought this or he might have meant this, but he's required to actually say it in his decision, given that he is the finder of fact. And because he's the finder of fact, we have to defer to his findings that Ms. Alvarado does not know. And that lack of evidence in no way, shape, or form can meet the department's burden to rebut the presumption of a well-founded fear. Otherwise, we're trivializing the meaning of fundamental. I know that respondent wants to cherry-pick statements here and there, but I think that the court can clearly see that she always couched it as in she didn't know. And that was the IJ's ultimate conclusion in his findings of fact, that she was unaware. So given that, there's no way that the IJ's factual findings can then support his legal conclusions. I don't think that the expert can be ignored either. This sort of also goes to the due process argument. Not only do we have the expert statements at trial that he can't imagine a scenario where they're not paying extortion and not being harmed, but then you have to look at his declaration that was included and admitted as his testimony as well, that was never reviewed by the immigration judge. So on one hand, they want to say, okay, let's ignore the expert because he doesn't know, but then we should pay attention to Ms. Alvarado because she also doesn't know. I don't understand how that can possibly make sense to resolving this case. And in light of Ortiz Cruz and even the higher standard in that case, I think that the court clearly has defined for us. With regards to the due process argument that Ms. Carlson began to start it before the conclusion of her time, this court has repeatedly, through Rodriguez-Arias, Cabrera-Vasquez, Alvarez-Lagos, say that we have to pay attention to the record evidence. And so if the critical issue in this case is whether or not that presumption has been rebutted, as into whether or not those threats are continuing, as into whether or not country conditions would have so drastically changed that the gang would have been eradicated from this area, that homicide rates would be significantly lower, that there would be actually a fundamental change, that record evidence cannot be ignored. Again, I think that the expert declaration would go to show prejudice, and I also believe that the Ms. Alvarado's sister's letter, and that's at the administrative record of page 259, I understand that she is also present in the United States, but she also says at the conclusion of her letter that she never received a solution or problem from them, and by them referring to the gang. So that, to me, indicates an ongoing problem, and it's clear from review of the record that the IJ never reviewed that evidence, never considered that evidence, and it may have pushed him one way or the other. So the exclusion is definitely prejudicial, and it's ridiculous for the board to sit back and say, oh, in the interest of efficiency, he had to conclude the proceedings that day, instead of taking the time to go back to chambers and issue a written decision, 30 days, 60 days later, and taking all of that evidence into consideration. So I think that there has been a demonstration of a clear violation of due process in this case. Just briefly on some of the other issues, this court has been clear that a lack of evidence from Ms. Alvarado is insufficient for the government to demonstrate a change in circumstances. And so given that, and given the affirmative evidence that was put forward by the expert witness and the country conditions and the documentary evidence, we think that the court clearly has defined for Ms. Alvarado. And unless the court has any other questions, I'll conclude my remarks there.
Thank you very much. We appreciate your arguments of counsel, and I ask the clerk to adjourn court for today.
Thank you.
This honorable court stands adjourned till tomorrow. God save the United States and this honorable court.